You look confused. Need some help?
Yes, I want to file a small claim, and I thought it would be easy, but I don't even know if I'm in the right place. If I live in Milwaukee County and the defendant doesn't...
Let's see. The proper county to file your claim is determined by the following: where the claim arose, where the subject property is located, where the defendant resides or does substantial business.
Oh, I am in the right place. Where do I go to file?
You need to go to the clerk of court, which is located in room 104. All small claim actions are handled in room 104, which include replevins, evictions, and small claims under a certain dollar limit. You must fill out a summons and complaint for any of these actions to take place.
What's a summons and complaint?
A summons is the form which is used to notify the defendant he or she is being sued. A complaint is a statement describing why the defendant is being sued. Both can be picked up and purchased from a cashier in room 104.
Thank you very much.
So I have to purchase these forms?
Yes, there is a fee for each form. Tell the cashier in room 104 which action you're filing, so she will know which form to give you. You should also know that there is a dollar limit in how much you may claim in a small claim case.
Okay, I'll keep that in mind. What else do I need to know?
When filling out these forms, you must provide the name and current address of the defendant, as well as a brief statement of the claim. Otherwise, the summons cannot be processed.
The forms are filled out. Now what? What should I do with them?
You have to go to room 104. The clerk will give you a copy of the summons and complaint so that it can be served upon the defendant. At this time, a case number will be assigned and a file folder created, and case information will be entered into the CCAP computer system. You can access this information yourself at the public computer terminals in room G9.
So now I have to serve the papers. I can take care of that.
It's not that easy. You can't do it yourself.
Who can do it then?
The sheriff or a private process server.
Private process server?
Yes, they can be found in the yellow pages or classifieds, but they will charge you for service, as will the sheriff.
Well, once the papers are served, what do I do?
You need to appear on your court date with an affidavit of service, which will be provided by the private process server.
What if the server can't find the defendant?
You need to appear on your court date with an affidavit of non-found, which is provided by the private process server. Request for an adjournment to have the papers served through publication. Now, remember, the kind of form you purchase will depend on whether you file a small claim, replevin, or eviction.
Oh yeah, I remember. I also need to provide the name and address of the defendant, as well as a brief statement of the claim. And then a case number will be assigned after I take the forms to room 104.
That's when you need to have the summons served.
By the sheriff or the private processor.
Okay. What else?
Okay. Then on my court date, I bring an affidavit of service, or if the defendant wasn't found, an affidavit of non-found.
Sounds like you know how to file your case. Do you know what to do on your court date?
No, I have no idea.
You'll need to go to room 400. Take a seat inside and try to be early. Oh, you don't need to bring witnesses yet. Step up to the bench when the clerk calls your case.
Catherine Moore versus Macy Bryan.
If the defendant does not show up, the judgment is made in the plaintiff's favor.
So does that mean I win?
The defendant never showed up to answer the claim. The plaintiff is awarded legal judgment. This means they only have the right to collect. 70% of all small claims cases end this way.
And if the defendant does show up?
They have the option to agree or disagree with the claim. If the defendant agrees with the claim, judgment is awarded for the plaintiff. If the defendant disagrees, the case will be turned over to the court commissioner. You then take a seat and wait for the court commissioner to call your case.
Catherine Moore and Nacy Bryant.
The plaintiff and the defendant will have the opportunity to present their issues and discuss them. Typically, a settlement is reached at this time. Remember, you have the option to agree to a settlement with the defendant at any time during the process. The court commissioner may refer your case for mediation at this time. During mediation, the plaintiff and the defendant will attempt to reach a settlement with the help of an uninvolved third party. If a settlement is not reached, your case will then be scheduled for a hearing. The hearing will be held again with the court commissioner. The setting is informal, but you will be under oath. You will present your claim, call witnesses, and provide documentation to prove your case.
Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
If you don't agree with the commissioner's ruling, you do have a right to a new trial before the small claims judge. Of course, there are forms and time limits for that. Everything you need is available from the court commissioner.
If the judgment is granted in my favor, how do I collect?
To collect on your judgment, there is more paperwork which you need to request from the court clerk. These are called Order of Financial Disclosure and Financial Disclosure of Assets forms. Notice the successful party is called the judgment creditor, and the unsuccessful party is called the judgment debtor.
What do these financial disclosure forms do? And what if the defendant refuses to supply that information?
The financial disclosure forms request information regarding the financial status of the unsuccessful party. Failure of the unsuccessful party to provide this information is punishable by other court-imposed sanctions. In fact, the judgment creditor can file a petition for a hearing that would make the judgment debtor appear in court and disclose financial status. If the judgment debtor does not appear, the court may issue a warrant for arrest.
But this whole process is just so I can get information about the other party's assets. How do I get the money that I'm owed?
You have to initiate collection yourself.
Let me guess. More forms.
There are more forms, but we're almost done. There are a few more ways to enforce payment: garnishments and writs of execution. Garnishment is a court-mandated order to collect your award from the debtor's earnings or bank account. A writ of execution allows the sheriff to seize the debtor's non-exempt personal or real property in order to collect the money. You may want to seek professional advice to determine if a writ of execution is appropriate for your case. A good idea, no matter what you decide, is to have the judgment docketed so it becomes a lien on real estate. In order to perform any of these, you must take the case file to the cashier in room 104 and pay a fee.
Do I have to file a financial disclosure of assets before I request garnishment or a writ of execution?
No, but it may help you decide which actions to take in order to collect the money.
What about court costs? Do I pay those, or does the defendant have to pay them?
Well, you pay the costs up front. The circuit court clerk will add these costs to your collectible judgment.
So once judgment is granted, I can determine the defendant's financial status by filing a financial disclosure of assets. I can attempt to enforce payment through garnishment or writ of execution. All of this, however, doesn't guarantee payment, right?
Right. For example, if the defendant is unemployed and has no property, there is no way to collect, so you may want to reconsider the appropriateness of your case.
You're right. I had no idea filing a small claim would take so much time and effort. I'm going to think about the information you have provided me and make sure my situation is appropriate for filing an action. Thank you so much for your time.
I'm glad I could help. If you do choose to file and have questions during the process, call the Small Claims Information Line at 278-4140.